Thank you all for coming out today. I know it's a really beautiful Friday afternoon out there, so I'll try to make this worth your while. So my name is Margaret Hagan. I'm a fellow here at the Center on the Legal Profession at the Law School, and also I live over at the D School as well, where I lecture and teach classes there. So Center on Legal Profession is a center. Lucy Rika is my colleague there that does wonderful events, bringing together all kinds of actors in the world of law together to talk about the future of the profession. So today I'll be talking about legal design, this kind of new field that I'm doing work in, that my students are doing work in, talking about how this could possibly lead to some really great innovations in how we serve people who need legal help. So today's talk, I'm going to cover three main points. One, what legal design is, what this approach means when I'm talking about that. Second, I'm going to talk about some of the projects and events that I'm running and some of the research findings that I'm coming across, hopefully which will be of interest to you. And third, we'll be talking about the class that we're experimenting with this quarter, Intro to Legal Design. Several of my students will be presenting the challenges that they're working on and hopefully opening the conversation for your input and thoughts, because they're pretty early in the process, and hopefully it's a great chance to bring minds together on their challenges. So what is legal design, if I'm using this jargony word? The main thing I like to get across, especially to a room full of lawyers, I'm guessing most people are JDs in the audience, is that when we come to law school, we're taught really how to think very critically, think like a lawyer, like our 3 years of tuition is supposed to get us. What I really want to argue for is to put on this new pair of lenses called design, where we're also trying to solve problems, just like lawyers are trying to solve problems, but in a more creative, experimental, and agile kind of way, and really putting the user at the center. So I think design is a really interesting tool set to complement the legal tool set that we come out of our 3 years of law school with. And it's really service-oriented. It's about figuring out what people want, what our users, our clients, our coworkers want, and then figuring out effective ways to deliver that to them in ways that they'll actually want to use. So in the short way, design, it's a strategy, a toolkit, a way of doing things that delivers usable, useful, and engaging things. Usable, meaning that people can actually use them relatively intuitively. They don't need a 3-week training course to figure out how to use that piece of software or that service. It's useful in that it helps them achieve a goal that they actually want, that it makes sense and is of value to them, and engaging in that they actually want to use it. They would pay money for it. It's not a taxing or burdensome experience to actually do it. So these are the three main metrics of design. And if you compare these to how legal services are currently delivered, you might find that we're wanting in a few of these different metrics. And that's my real interest, is how we can improve the user experience of law, both for the people who deliver it and for the people who are on the other side, the lay people. And so design thinking, which is design is a practice that people spend 4 years and get professional degrees in. And I don't expect lawyers to, go back to design school and become expert designers. But what's really useful is this concept of design thinking, which is taking a lot of those skills, those tools, those methods and approaches from that world of professional designers and bringing it into our own field and seeing how we can make use of those creative problem-solving methods in the world of law. So that's what really goes on over at the D School. For those who don't know, the Institute of Design, otherwise known as the D School, is supposed to be a hub on campus where we take these design and innovative strategies and figure out how they can be applied to other fields, whether that's in the medical school, in delivering better patient-centered care, or in the education school and how we get students to learn in better ways. And now I'm trying to really import it into the law school and how we deliver legal services. And so this kind of design thinking movement, you could say, is about 15 years old, and it's taken off in the world of management, in the world of medicine, and I think it should be taking off in the world of law, because essentially we are also a service-driven, problem-solving oriented profession. So my question really is how much of those design principles and approaches can we make useful in the world of law? And this is what I'm trying to figure out through my work and through the classes. So to give a little more depth to what design is, we can think of it as a process, and not to be too reductionist, but we can think of it usually in this kind of loop. where we start off, and before we know exactly what the problem is, before we define what our challenge statement is, we talk to a lot of people. We try to figure out what the stakeholders' perspectives are on the ground, and only from how the users present their needs and their goals do we then synthesize that into what our problem to solve is. After that kind of synthesis, that thoughtful, user-driven synthesis, then we start to build and test very quickly. So this is one of the hearts of the design approach, is instead of talking about potential solutions and just getting caught in brainstorms or spitballs, build and test, build and test. So build rough and ready versions of your ideas, put them in front of your potential users, and get that feedback early. And only from there do you start to scale and really invest resources in your idea. So designers' mindsets, there's a bunch, but let me highlight a few of them. So one of the central ones, which should be familiar to most lawyers too, is to really be in service of your users. So knowing not what their short-term transactional needs are, meaning what legal document they might need to be completed or a case they need to be resolved, but what their underlying goals are, what their underlying frustrations and needs are, and trying to be in service of those bigger needs. Also, and maybe a little bit challenging for a lot of well-educated, highly degreed kind of professionals, is to take a beginner's mindset and really try to figure out why is the status quo the way the status quo is, constantly questioning why and trying to use this naivete, even if it's a pretense, to try to figure out, can we go back a few steps and design this system in a better way, design how we interact with law a better way? Why do we need to live in the system that we do? Another one that's close to my heart is really being visual. This is how I coped with my 3 years of law school. I don't know if there's any cartoonists or other visual people in the audience, but really getting ideas across in non-textual ways. I'm not sure if it's a millennial thing or a generational thing, but people don't like reading anymore, and we as lawyers are so dependent on the written word and on text. And if we're going to be effective communicators, we need to start thinking in more visual ways to really mobilize and enhance comprehension. Another concept that might be a little bit foreign to lawyers is building to think. So instead of thinking through writing or thinking through talking, actually trying to create what that end product, create what that service is, and before it's perfect, just building to think it through, to get to a better version instead of trying to always be perfect. Another thing I'm a really big advocate for is bringing non-JDs into the world of JDs and having non-lawyers on teams to bring their outside expertise in, whether it's doctors, engineers, educators, having more interdisciplinarity to find better solutions to legal problems. Let me go through. One of the fundamental ideas of being a designer is that everything is a prototype. So not taking things as precious, being able to scrap things, being able to take criticism, even if you're a type A personality and you like things to be perfect, being willing to put stuff out there that's a little bit rough and ready in order to get feedback and be more collaborative, be more participatory, to have that early feedback so that you know whether you're on the right track or not. And the real goal of that quick and rapid prototyping and quick testing is that whether you're trying to develop a product or a brief or whatever your final output is that you fail early before you've invested, whether it's a lot of time, a lot of money, a lot of other resources, that you can scrap a bad idea or a bad design at this really early stage in your project timeline before you get too late. And that's what the quick building and quick testing really gets you. So with this definition of design process and design mindsets, how do we make this useful in the world of law, if we can at all? This is my big question. I think the answer to this is yes, and now I'm thinking of how, though we're still trying to find those great case studies of how this has been brought effectively into legal services, which I'm hoping my students will help me get those case studies. So I think I'm coming into this with the predominance of the world of legal tech. So commonly, when we talk about innovation, we really talk about technology and using either software products or otherwise to enhance the power of lawyers or enhance the power of clients to do legal things. But what I'm interested in is bringing design into this equation, that it's not all about what software we can produce, but it's really how do we make tools that people actually want to use and can use. And yes, they might very well be technological, but we need to have this perspective of design and really be arguing for usability, user-friendliness, and really exciting, if not fun, products in the world of law. We don't need to have, I'm on autopilot or something. But if we really start thinking about the user and not just the cool technology, but really about what can we serve the users with. And so I have a public presence. I write about this a lot online, and I get a lot of people calling me with their problems in the world of legal services. And these are the buckets I'm finding are really predominant in the problems that legal organizations are coming to me with. The first order, which is usually the first thing when they think of design, is just how do we make it more comprehensible? How do we make our information either more graphic, more flowcharts, more cartoon-like, anything that gets people to actually pay attention to legal information, if not actually follow through on it? So communication is the first big area where this can be useful. Second is just the user experience of clients with their lawyer. So what are those better conversations, whether it's about how can we make the pricing conversation less uncomfortable, how can we make our clients actually follow through on finishing their will when they start it off, but like how do we improve all those service relationships, all those touch points when we have to deal with our clients. Another big bucket is like, what's that new app? We want to build a new app, we want to build a new website, we want to engage people in a better way or get them to do part of the legal process themselves. That's usually a request from courts or legal aid groups. How can we build those new tech-based tools that will help this kind of new era of half DIY, half expert-based legal processes? And the final one, the one I'm really interested in, is how we actually change how we work as lawyers in our legal organizations. So how do we become less siloed? How do we share knowledge more? If we're working like in a startup environment or with a fast-moving tech team, why do the lawyers always need to be the cold water that are slowing everybody down? How can we lawyers inject our knowledge into the product teams that we work with or the other, our clients in a more agile and quick way where they don't hate us so much? So these are the kind of 4 areas where I'm seeing there's real potential for these types of methods to make a difference. And I've just fleshed them out a little bit more. So design for legal communication, it's about improving comprehension, getting more non-text in, though the slide is very textual, I'm really sorry about that, and trying to take advantage of interactive digital tech to make better kind of legal communications. Design for legal services, these are the directions I'm thinking of, whether it's like total non-tech solutions of just better conversation tools, better kinds of relationship tools between clients and attorneys, to more tech-oriented ways to collaborate between lawyer and client. And then finally, design for legal organizations. Yeah, a lot of it is taking a more process-based approach to how organizations work. So instead of thinking of it as an art, thinking of it more as a process, and then finding ways to target inefficiencies, to bring collaborations together. So let me go, now that I've talked in the abstract a lot, let me show a few of the projects I'm working on, and hopefully this will illustrate some of the points I'm making. So what I've been doing, I had the luxury of being a D-School fellow last year, which basically meant I got to live at the D-School and do whatever I wanted. So I took that as a chance. My dream is to have a kind of R&D lab for legal services. So what I did at the D-School, and now what I've been doing here at the law school, is running lots of events, trying to figure out what kind of who out there is interested in this and what kind of projects are ripe for this type of work, and then what the methods are that are best suited to it. So so these are kind of a recap of what I've been doing in this attempt to prototype an R&D lab. One is running lots of hackathons, design sprints, pop-up classes, exploratory events. Another is putting a lot of stuff online and seeing what sticks, what doesn't, what gets people tweeting or interested or reposting my blog posts. Third is doing research about how people use the internet for legal help. Fourth is actually building out some of these products, which I'm really excited to show you today. And then fifth is the class, which we'll talk about in detail later. So some of these events. So I started just with immigration. We had a hackathon for 2 days. People just came in. I put up a poster online and around the law school and D-School and said, hey, who wants to help foreign students with F1 visas figure out how to stay in this country after they graduate? Come, we'll spend 2 days and just try to figure out some solutions. And then we did partnered with Fidelity Investments. We did a 5-day version of that, but with wills. How do we help people make better wills? We did this partnered with some criminal justice partners, some prosecutors, and then also some defense attorneys about how we could make plea bargaining, how to improve the conversations between defendants and their attorneys. We partnered with Fidelity Investments again, this time for a 2-day design sprint on how to make very, very complicated financial disclosures mobile friendly so that people would actually read them on their phone before making financial decisions. We did a design sprint one night with lots of court staff from the Alameda County courts. They wanted to make guardianship procedures much more DIY friendly for people to do it without lawyers. So they came in and we did a whole envisioning session of what could they possibly do to make it more user-friendly. And then last December, I just focused strictly on visual law. How do we just make better graphics? And then a few months ago, up in the city at Code for America, we had one around Know Your Rights. So we had a lot of kind of civil rights organizations, ACLU, other people come together and say, how could we present things better than a PDF flyer that tell you as a young person what your rights are? What's a better way to communicate your rights? So what I've been learning from all of these, you can see it's all over the place. These are just kind of scattershot attempts to try to find people out there, kind of put up a smoke signal, who else is interested in doing creative, innovative, design-driven kinds of work. And out of this, I found lots of partners and lots of potential projects. But what these events really serve of is to put up lots of ideas and figure which ones can stick. Put up the ideas, test them. Also test partnerships. Who out there, which legal organizations would make good partners on these kind of projects? And then also bringing in a world of students and non-lawyers into this world of legal services. I think that's most exciting, is to see non-lawyers really excited about solving these problems. So what I've been doing online, this is how I really got started. I just started a blog. I would advise any JD in the audience, if you want an alternative career track and don't want to become a corporate lawyer, start a blog and a Twitter account and just start writing about what you're passionate about. Because honestly, people think you're an expert, even if you're just blogging, which is amazing on the internet. So this is like, I got off a phone call 2 days ago with a chief judge in Florida who in love with my website, because people out there are hungry for new ideas. And honestly, I'm just putting together what other people have done, but putting it in one central place. So the judge says that she and her team just page through all the blog posts I do about interesting court innovations to get inspired for their strategy report. Judges and lawyers are hungry for new ideas, and I'm trying to build repositories for at least them to get that initial exposure. The other thing I'm doing, and partly is self-interested, because during law school I created lots of drawings, lots of visualizations of law. I created a library where I just put all my drawings and other people's interesting visuals, hopefully to set a bar about what good visualization of law looks like. And what I've started, especially out of all the classes and events I've been running, is like a toolbox online for all the methods, all the tools, all the best practices that I'm coming out with from these workshops into this online repository, so that instead of having to answer emails with long explanations of how to make a good graphic, I can just post them all on here and send people a link. So some of the research projects I'm doing. So this is my real passion. This is one of the big things I want to figure out and help solve, is when people use the internet to seek legal help, how do they do it and how can we make it better? Because right now, it's not good. What are some of the better ways to present that complex info so they actually engage and they act upon it? And just overall, how we improve the experience. I'll keep repeating that phrase over and over. So let me tell you a little bit about what I've been finding. I've been running lots of surveys online, giving people tasks to do, legal searches or legal problems, and seeing how they use the internet in the wild, having them report back what kind of resources they come across, what they trust, what they understand, what they don't. So I've been looking at trying to group them into these, who are these different main categories of people seeking help? What do they trust? What are their mental models? So here are the 3 categories I've come across. One are the people who want to do everything themselves. They're total DIY. Others are totally cautious. They want to hand over all their legal problems and decision-making over to an expert, probably a paid lawyer. And the third is somebody who really just wants to have a parental figure just take care of everything for themselves. They don't even want to shop for a lawyer. They just want their father or another kind of parental-like figure tell them exactly what to do. One thing I've been finding out a lot is that people rely on their social network. Whenever they come across, whenever they feel like they have a legal problem to solve, they really want to reach out to people on Facebook, over the phone. They want a trusted circle of advisors to tell them what to do before they make any choices at all. There's a surprisingly large group, though still a minority, that loves Yahoo Answers. And I don't know if you've ever used Yahoo Answers for anything, but people they find Yahoo Answers, whether it's because it comes up first in their results or otherwise, they spend lots of time on Yahoo Answers going through conversation after conversation to try to sort out and parse through and find valuable information. But they want to be in that anecdotal, peer-to-peer kind of environment. There are other people, and I would say this is a high percentage of the people, will only click on the first 2 or 3 answers that come up on a Google search result. How Google search presents information conditions so much of what people do online when looking for help. If we could change Google as the portal, we can change a lot about how people use the internet and how we get better information to them. And then there's another type of user who's totally over-diagnosing. You probably know this from the medical context as well. But somebody who ends up going through page after page of results and ends up coming up with a diagnosis of legal problems that probably far surpasses what's actually going on in her life. Another really interesting thing is about trust. So how people tell whether a legal site is trustworthy or not, a lot of it has to do with how many citations there are, even if they're never going to click through on them, even if they're totally irrelevant. If it has citations, they trust it. The same goes for a government or court association. But they can't figure out the jurisdiction thing. Most of them end up trusting sites that are totally irrelevant to their jurisdiction, but because it's associated with some official-looking thing, they go with it. But a lot of their online searching is actually not about trust. Trust matters in some cases, but mostly they just want to find stories. They want to be reading through people's stories about how they went through a similar legal task, and then they can compare notes. Does this story sound like mine or not? And I feel like there's something there. And let me segue a little bit into another finding. So what I found is that taking this process-based approach, that most consumer, lay people going through a legal problem, go on the similar kind of path with these similar kind of stop points, touch points, whether it's realizing they have a legal problem or that itch is actually a legal itch to pursue. But before they actually take any first step, they have to get activated, engaged, oriented. There's so much priming and onboarding that needs to happen before they actually engage with the legal system. And then once they're in the legal system, there's a lot of decision-making that goes into it before they actually consult with a lawyer, hire a lawyer, anything like that, which makes me think that all of these different touch points are new products that we should be developing, or new product families we should be working on in this world of consumer law. And I see LegalZoom in the audience. I'm looking at you. But really, so much of it, before they actually even get to dealing with the court or the lawyers, it's really engaging them, orienting them, giving them some kind of triage and diagnosis experience, and then actually getting through actually taking legal steps and making sure it's quality and everything like that. So this is where I see the real potential for new startups. Law students build some of these, LegalZoom build some of these, for what should be developed for a real kind of better legal experience for lay people. First is better portals online or on the street or other ways to give that engagement and orientation to get people to better legal help before they end up at either a spammy site or trying to do it themselves or some other less than optimal outcome. The second is once they do get kind of oriented into that world of law, is giving them really great intuitive navigator tools that take them step by step through the process. And then the other thing to go along with that is decision-making tools, because this is the other usual freezing point where people end up not pursuing legal help, is around the decisions. If there's more than one path open to them, relief path open to them, they don't know how to weigh the options. They don't know how to assess price, timeline, the outcomes for the quality of life. They don't know any of that. So we as lawyers need to figure out how to give these kind of tools that help them calculate that or play with those possible outcomes. So let me talk a little bit about some of the models I think can be part of these, and then let me talk about some of the projects I'm building that hopefully can help with these as well. So in all those sessions I talked about earlier, those design sprints and hackathons, we've tested a lot of different models, so I'll tell you the ones that have been really popular, that have tested really well. One is dashboards. People want dashboards on top of their legal matter or their legal experience. They want it gamified so they can feel progress or they know how far they are compared to a normal person on that track. They want a map. This is like #1 request. People want maps that give them a bird's eye view of where they are in the world of law, where they want to get to, and what those steps look like. They want responsive flowcharts, and this goes back to that kind of playing around calculator decision-making tool. They want something that lets them say, if I do this, then I'll be in this bucket, and then I can do that, and that will take me here. But they want something they can play around with. They don't want a textual description of, like, if you file for this, then this will happen. They want something that they can play and see what different paths would look like. They want a strategy calculator. They want something that they could enter in different values and see what the outcomes would be. And they want limited menus. This is like one of the main findings, is they don't want all the options under the sun. They want very constrained recommendations of you could take 1, 2, or 3 paths, and these are what the different paths would look like. But they want kind of a curated set of options available to them, because otherwise they get overwhelmed. Okay, so let me talk about some of the tools I'm building out, and my designer, you may know, is in the audience, so I'm going to shout out to her for her great work. So the 3 things I'm working on building out, kind of coming out of all that work. One is court coaching system, where we're working with some of the local courts here, Santa Clara and Alameda, to build kind of reminder messaging to their litigants. And second, we're actually building a responsive flowchart that does that triage in a visual, playful kind of way. And then we're building a step-by-step legal navigator. So let me just show you a little bit about those. So the court coaching project, it's really to help people who have court dates and then likely will not show up for later on court dates to just be reminded of when those court dates are and where they are. Kind of if you're very popular in hospital systems right now to get these reminders of your upcoming doctor's appointments. Why can't we have the same for litigants in court? So we'll have the either the attorney or court staff member kind of managing when people should get reminders and what they should be reminded of. And then what we're trying to do with the court is start off with just that pure like reminder system, like when to show up, where to go, what to bring with you, etc. But our goal is kind of expanding out those reminders into a full-blown coaching system for all those other kind of non-legal advice types of things. So like stage 2 would be like what bus to take to get there, because we find that's usually a breaking point of why people don't actually show up to court if they don't have public transportation. What clothes to wear, what language to use. So we're excited to think about that little pilot with the court expanding out to a much richer kind of coaching experience. The other big project I'm working on is a pro bono training platform to train lawyers to represent unaccompanied immigrant minors who end up in the US, and teaches them how to represent the kid both through the state court procedure and then to the immigration procedure so that the kids could eventually get a green card and stay in the country. So what we're doing here is building that visual flowchart triage. So what we heard from our testing is people, even the lawyers, do not want long passages of text to figure out what immigration relief to be applying for. They want visual, clickable, and short sentence style presentation of that. So my designer, you may know, has helped me build this really responsive, playful visual flowchart that helps you figure out which immigration, like visa or other status, you can apply for. So you answer a question, it takes you to the next question, and then you can zoom out and see a bird's eye view of what questions you answered and where it's taken you to, which options are open to you. And then you can also go back and play around and see, if I had clicked this, then would I have had these options open? Because we find that people, as they're presenting their case, doing their intake information, they don't always know which answer is right, or they might be in between, so they really want that playing around feature. The other main product inside that Legal Navigators umbrella is the step-by-step process guide. So again, most of that right now is buried in PDFs or long workbooks that you have to page through. It's all printed out. It's not interactive. So we made it much more visual and clickable so that it's a smart checklist, if I can show you. So all the steps you have to take to get a guardianship procedure are in this kind of checklist that you can save and come back to. And you have the forms embedded right in there. And you go step by step through the 3 different phases: state court, immigration, green card. And again, this is all coming from our testing that lawyers, pro bono lawyers, don't want that PDF experience. They want something on their desktop, clickable, savable, and then the next iteration will be collaborative so that you can work with your team or your client on this platform to enter information and save and work as a team. So I have to give, again, big thanks to you, Mano, for all the great design work on that. So that's the projects I'm working on. But let me talk about the class before I hand it over to them to present their challenges that they just started on. So the class is kind of my way of taking all those short exploratory pop-ups and hackathons and expanding it into a 9-week class and doing much larger partner engagements. So we have real-world partners that all of the students are working with. So I worked with the partners to help them scope real challenges that they're facing in their organization. And that could be potentially worked on in a 9-week class in a productive way, so not too ambitious. And then the goal for the students is to create some kind of concept pilot that the organization could take and run with after that 9 weeks design cycle is over. So who I was hoping would take the class, and I was lucky enough to get them, are people, students from across the campus who are really interested in either new careers in law. They don't necessarily want to be the traditional lawyer. They want new ways of solving problems. And also people who have that ambition to really either start their own startup or come into an organization and be intrapreneurs and really push organizations to be more innovative. And I was hoping to offer them, I hope they will get these skills, is both to be like more design-oriented and be able to do design work, but also really the main learning outcome is just to be more user-oriented, to really understand the clients and really pay attention to the people around you, the clients you're serving, your coworkers, about how to operate in more collaborative, experimental kind of ways. And the outcomes, like I said before, we're going to be creating action plans and pilot proposals. So we're going to be creating service designs or product designs that the organization could actually pilot. And really, this is the class I wanted to take when I was in law school. So it's working with real organizations, which is really exciting. But it's also, what I found is that a lot of law schools offer classes that are tech-oriented, build apps or come up with things, but usually it's asking the law students just to come up with legal content to fit into an existing app or an existing tech platform. And I really wanted a class where the students get to define what the solution is. They're not trying to just feed legal content into an existing platform, but they're really coming up with new types of solutions, and they get to be very creative. And what I'm excited about coming out of the class is that we get case studies about what works and what doesn't in bringing design into legal services. And we also get to bring the partner organizations along with us and try to get them to work in this new kind of way. So the partners we're working with in our class, we're lucky enough to be working with a great group of organizations. So Oric, the law firm, has 2 teams with us, one focused on litigation, one focused on transactions. We're working with the Eviction Defense Collaborative in San Francisco, with One Justice, with Hewlett-Packard, and on campus with Stanford Venture Studio and Startup Garage. So I'm going to stop talking, and I'm going to hand it over to students to present the challenge they've been handed to by their partner organization. And then hopefully we can, if you have, at the audience, have any feedback for their challenges, any thoughts, insights, et cetera, we can have a discussion around that. So is someone here from the EDC group? Yeah, Jane. Do you want to take 2 minutes and talk about the challenge?
So Eviction Defense Collaborative is a nonprofit in SF that serves almost all the clients are in SF, although they're open. Should I do this? Okay, I'm Jane, and I'm in a team of 4 students. And as I said, Eviction Defense Collaborative helps people with their eviction, mainly unlawful detainers that they receive in SF. And this is a really quick turnaround process because in California you have 5 days to respond, and the cases are generally 3 weeks long. So the environment in the office that we visited last week was very high intensity and a quick turnaround, and many cases flowing at the same time among multiple different people, from staff attorneys to volunteers and admin. There are the executive director who came and pitched his project to us was that he said that they have a workflow issue on how to get their most basic job done. And this has a lot to do with how the workflow is structured, from clients coming in and presenting their problems to volunteers who do a long intake process in a handwritten manner, which takes about an hour to an hour and a half. And then it's transferred over to attorneys who input the information into computers. But it's not as simple as that. There's multiple iterations of volunteers transmitting information to attorneys and back and forth and cross-checking information. And they use 4 different processes to put the information into computers. So they have multiple software programs, and the information doesn't necessarily overlap into the same database. So there's sometimes repetition, multiple points of input, and so we heard a bit of frustration around efficiency, basically, and being able to cross-check information across documents. So the main goal that we heard that I guess we were asked to help with is to help volunteers be more empowered, so that they, instead of being encumbered with a long intake process in the beginning, they can manage the cases from beginning to end and have more of an ownership over the case. And so the attorneys wouldn't be so encumbered as well in the process of inputting data, for example, and that they can be more present to help clients in trial or hearings if they need to. So on our end, as mere law students who aren't like Salesforce consultants, for example, and we're not trained in that way, we're trying to avoid just being technical consultants and saying, oh, this software would be good for you and just software will solve all your problems. And we're trying to see the workflow issue, trying to see which steps are encumbered or repetitive, and trying to take a big picture that daily staff or volunteer people can't see in their roles. And so far we've done just one site visit, one conference call, and we still have much more to do in terms of understanding their long, complicated process. But I would love to hear any feedback you have about even the small steps we've taken. Yeah.
How many applications for this service do you receive, and how many do you take, and what is the factor which enables you to determine whether they have merit in their request for defense, or whether they should not be represented because it's their own fault?
Okay, so apparently they do 8 pickups per day, so that's eight cases a day. We were told that there are 600 eviction notices in SF a year, so I mean, presumably that's a very small fraction of the eviction notices that actually happen. And among those that have merit...
Wait, you pick up eight per day, but there's 600 per year?
No, 1,600.
Oh, 1,600.
Eviction notices per year in SF. And since I can't speak for EDC, and I'm still learning how they decide who has merit, I haven't studied the exact eviction law around that. So I can't say, I guess, with a lot of authority, what they've based the merits of the case on. But I think, habitability is a large practice that happens with people having habitability issues, not paying their rent, and then landlords issuing eviction notices. So I think that's probably a common box that is checked.
Well, we know there are a lot of bad landlords, but there are also a lot of bad tenants.
Mm-hmm.
And I think that if I were to participate in something like this, I want to make sure that one of the globular circles up there was to make the law fair and just and equitable. Where I would want to make sure that I wasn't just impeding the process rather than making the process work. I don't know if I made myself clear, but you know, you could have a lot of volunteers running around creating hopes for people and also filing a lot of responses, but those people really didn't deserve your help.
Right. We haven't looked at individual cases enough to see how fairly the volunteers are processing the claims. Yeah. Any advice for us as we go forward?
To the next group, and then we can have a collective if people see what's next.
Thank you.
Everybody hear me? Great. Hi, everybody. I am Ryan Hollander, and I'm here with Sam Schroeder, who's on our team in the audience. We're also working with Sebastian Alvarado. And we are really glad this quarter to be working with One Justice. One Justice is an organization that promotes pro bono services throughout the entire state of California. And in particular, we are working with One Justice on trying to close the justice gap in pro bono family law cases. So in California right now, there are approximately 6 million people below the poverty line. And approximately 4 million people every year go to court and are unrepresented in their case, many of those people because they cannot afford an attorney. And in family law cases, the problem is particularly dire. Approximately 70% of family law matters, of parties in family law matters, do not have an attorney, many because they cannot afford one. And in fact, many parties who begin with an attorney by the end up without an attorney because they can't afford one throughout the entire process. So One Justice partners with legal aid organizations throughout the state that also work with pro bono coordinators at various law firms throughout the state, trying to recruit attorneys to serve these clients. And the main challenge that we have for the quarter is figuring out how to increase the number of clients who are served. I'll just add a final note. This is a particularly difficult area for clients in that often the matters involve a lot of emotional stress as families are taken apart in front of the stand, in front of lots of people. They go for indeterminate lengths of time, usually very long but uncertain, which causes lawyers sometimes to be wary of these cases and clients themselves. And it also tends to be a legal area with a lot of significance, but a high degree of specialty. So not every lawyer always feels comfortable in these sorts of cases. So that's the goal we're excited to work on this quarter. Thanks.
Did someone have a question? Or no? Okay. So ORIC litigation, no one could be there from this team. Unfortunately, they have classes. So they're working with a team of litigators at ORIC, and ORIC brought them this question. How can ORIC drive profitability, be competitive in the marketplace, while also improving the value it offers to its client? So it's a hard balancing act. Every law firm is probably dealing with the same challenge. So the design team is working with the ORIC litigators to figure out, the current status quo and then what could be improved, and getting that balance between a law firm being competitive and profitable, and then also increasing value, transparency, as well as keeping that associate training and career advancement inside the firm happening. Oh, sorry, they couldn't be here today. ORIC Transactions Group.
Hello. So my name is Alexander. I am probably the only non-lawyers in the class. I am a third-year election engineer in the election engineering major, PhD in the election engineering department. So I'm taking this class because I felt like this class is very interesting. I can probably use some, outsider thinkings to solve some law firm issues. So for this, for the ORIC transaction group, so we're faced with a similar problem as the litigation group, what we're trying to work on is they have a lot of renewable energy projects. They're representing either the buyer or seller on the market to identify either like potential failures in the transaction process, and also trying to work on the purchase agreement so that the transaction can go very, very smoothly. They also focus at the very end. They also work on the logistics just to make sure that every party is happy. So the challenges that we're faced with is trying to improve the efficiency in the entire transaction process, as well as improving the client happiness after. So obviously, there's a lot of challenges. There are many, many ways we can go about doing this project. So right now, what we have worked on is having conference calls with the potential stakeholders. Mostly with the law firm, we're also trying to see if we can contact the clients to figure out their side of a story. So basically, we want to know what kind of issues they're dealing with and what kind of improvements we can work on, whether or not on the system level, probably from a process level, like in the process chain, there may be like potential roadblocks that we can improve with either technology or with some other human resource distributions or something like that to improve the entire efficiency. Or is it because it's a structural issue that staffing might come into play, that because different parties have different interests, that we might be able to work with that and work with the lawyers and associates and partners to see if something can be done with that. Yeah, so that's what we're working on. Okay, questions?
Just wanted to ask about who at Oric joined your group. Who were you consulting with? Was it partners, associates, paralegals, other administrative staff?
I can answer that.
Okay.
So the partnership is. The partnership with the class overall came from kind of higher ups in Oric who are really interested in innovation and experimenting with new ways of working in the firm and serving their clients. And then they found good practice groups for us to work with. And so as the students work with those practice groups, they can talk to all the stakeholders. So we're not focused on a specific user yet. They first get to talk to a bunch of different stakeholders inside the firm. And then they get to decide in the next few weeks where to focus their interventions.
I'm a senior paralegal at Kirkland.
Oh.
And a lot of times when you do projects, things move so quick that you don't even really get much traction on some of your projects.
Say that in more detail?
Corporate.
Like in the legal project, yeah.
Yeah. Kirkland just does big deals. The pipeline's constant. So we're closing deals, we have to bill. And then anytime you want to do something to make your life a little easier on the side or something, bring in some of these business concepts or knowledge management concepts. Yeah. Great idea. I gotta go. And so that's the thing that's constantly, you spend about a week, and then it dies down because you gotta go work on something that's billable. So there's a huge need for it. We're trying to slow things down enough, but we're trying to find that hook of what's the value there. Once we find some traction, it'll take off. But
I think that's one of my organizational design questions is how do we let better ideas bubble up inside law firms and actually go somewhere instead of fizzling or dying or people starting a startup outside of the law firm rather than deal with the internal. Yeah. I don't know if you have thoughts on that, but we're interested in that.
Yeah, I think one of the hooks, and I'll just say it, there's UCCs. People take the UCC class, you have to file these UCCs. Big risk to the firm if it's filed incorrectly or if you cancel a filing by mistake. So 3 years ago, there was a big court case. 2 firms screwed up, and JP Morgan lost many millions of dollars. So that kind of thing is a hook, potentially to actually bring process in and say, we need a process to limit risk at the firm. How do we do that? Yeah. Because what happens is if you're first year, second year, third year, and you realize, I'm going to do something else, the partners can't really necessarily check all the work that gets done. So throwing that out there is it's sometimes a problem. To limit the risk of the problem, that might be a way to go.
As one of the selling points. But, I think that's right.
This is very exciting stuff.
Yeah. Okay, let me go to the next group, Hewlett Packard. Ahmed.
Thank you. Hi everyone, my name is May. I am working with two teammates on this project for HP. Unfortunately, neither of them could be here today, but they say hello, Mike and Kenny. So we've been given this kind of huge conundrum to solve by HP, but we're going to keep it general out of respect for privacy issues. So right now, I'm sure many of you know that HP has split their corporation into two parts. One is for consumer-based products, and one is for enterprise. We're working with the enterprise side, and particularly with their legal department, they're looking to make things a little bit more efficient and spread their finite legal resources a little bit better. So what's going on right now is that we have this bottleneck in their transaction process. So for SaaS products, say you are a customer, I'm a company, I need to buy cloud services, I choose HP, we sign a contract. This contract then has to go through my salesperson, and likely I'm going to fight back on some terms. If I'm a large enough company, I may have my own contract that our general counsel has okayed, and that's what we like to use for all of these purchase deals. Or it could be something that we received from HP, but our GC had marked up all over the place, and then we're fighting back and forth on these terms. It goes up through the HP legal, comes back, up through HP legal, comes back. So this takes a huge amount of time. But then also on the HP side, they're describing it as they have way too many lawyers involved in way too many deals that are way too small. And so they're thinking that their resources could be better used, their time should be better used on maybe more important or maybe larger deals than on these small contract terms, maybe about jurisdiction. That doesn't probably really matter. Maybe HP doesn't care. Maybe the company doesn't care. So this stop right now is causing problems on both sides because the customer then is frustrated because it's taking so long. And they may actually be losing customers because of it. So our challenge here is really to oversee the process and see where we can intervene to maybe smooth it out and open up the constriction in the middle a little bit more. It's slightly helpful that they've been trying to think about this themselves internally. Two groups within HP have actually developed their own solutions to this problem. One is software-based, the other one, we're not quite sure yet. We still have to get there. But part of our job also is to take an outsider's perspective and evaluate whether or not those two solutions internally developed are the right fit for this problem. So I think we're almost working on three problems at once, seeing if A, B works, and if they don't work, then developing something ourselves and present it and kind of go solo on them. So if anybody has any ideas about this process, I would be all ears. Yes, sir.
This is, I think, one of the problems you're dealing with in the fact that in the United States, and I don't know very much about the legal processes around the world except common law, mostly the British background area, and also the civil law and the French orient. But in the United States, we have an adversarial situation. Litigation's adversary. In this case, you have an adversary situation between two companies' legal staffs where both essentially want to create a deal.
Right.
But the obstacle seems to be the fact that both sides have requests that are incompatible.
Right.
So why don't you set up the situation in one way by saying, all right, let's ask the other party, why is it that contract term is not appropriate or acceptable, and try and work around it, or set a deadline. We'll pass it around 3 times, and if there can't be an agreement, we'll just cancel the whole thing and go on to something else. Because a company, regardless of its size, if it can't reach a deal amicably with another corporation on a reasonable set of expectations, you shouldn't be doing business with it.
Right. No, absolutely. That's potentially one of the things that we're brainstorming. Maybe we're coming at solutions from the customer side, the user's perspective, or actually coming at it from the other side's perspective, from HP internally. And maybe they choose to lop off contracts that are too complicated. Or we were thinking that we may make customers actually self-select into different price ranges or something like that, where like if the customer actually really values using their contract or they have to get their terms, then there may be a willingness to pay for it. Whereas the other people, if they're okay with just using this generic HP contract, then we don't need, why are we even here? We can just go through. And so that'll probably open the door a little bit, but that's something we're thinking about as well. But I think this is definitely an issue of competitive advantage for HP. There's so many other companies right now that are doing the same thing, like Amazon Web Services, Microsoft. They just, like, if they're losing time on contracts, like, they're just kind of screwed. Did you wanted to say something?
Oh, just that your clients, HP, they don't necessarily want to create a better vehicle for their contract to be challenged. However, one thing you could do, especially from a design perspective, is use machine learning to go backward and say, what are the clauses that are most often challenged now? Give the HP legal team graphic representation of where touch points might be, and then perhaps a sensitivity analysis that gives them an idea of positive economic outcome of being more flexible on most important terms. And then they could, because you've got sophisticated players on both sides, the GC on one side, HP on the other. And that might give them an economic basis for softening certain areas of their form contract, and I think the graphical representation that might help to, in a sort of Pareto sense, say, okay, that's where potentially we can give a little and get something better.
Yeah, I really like that. Thank you. We brainstormed a little bit, something similar to that, in terms of we need to look at lots. I don't know if they'll allow us to go through their data like that, but we could propose something like that, whereas you take all of the data from their past contract, see which particular places are the most pain points, where it's labored over the most, why is it labored over the most, or have HP go through and see which terms they actually don't really care that much about, and they're able to give more freely, then maybe we can automate the process a little bit. And for the contracts that are really, really troublesome, then we actually send it up to like real lawyers. Thank you very much.
We have one more group, which is on campus. Michael, do you want to Stanford Venture Studio Startup Garage?
Hi, my name is Michael, and I'm part of the group that's working with the Venture Studio at the Graduate School of Business. Yufat is here. She's also part of our team, and Divya, who couldn't be here today. So we're working with the Venture Studio, which is a program at the GSB, and it's made up of about 60 startups, really early stage startups that applied to be a part of the program. And the program coordinates networking opportunities, has workshops for startups to help them deal with common issues, and also has a staff that works as a resource for advice for whatever issues these early stage startups might be facing. So the problem that we're taking on is that many of these teams don't know what their legal issues are, or alternatively, they know, but they don't have time to address these issues. They lack accessible, trustworthy resources to figure out these issues. They can't pay, or they don't want to delve into touchy subjects. So, determining how they're going to split up the equity among the founders, for example. And so this leads to possible risks, and possibly huge risks down the line. They could increase their liability. It could be either contractual liability or tort liability. It could make them unattractive to VC firms down the line if they screwed something up early on. They could lose their intellectual property rights. They might lose their ability to contract with large companies or governments. We talked to one startup that is targeting local governments, and they're worried that if they screw something up and kind of overlook something, that a government won't want to do business with them. And also trade secret lawsuits, specifically if they hire an employee from another company and don't kind of think through what that entails before the hiring. So some examples of what teams are doing right now when they do kind of reach this second part where they know they have a legal issue. They might email the Venture Studio listserv, which has a ton of people on it, and that kind of devolves into an email chain of conflicting advice and people saying, go to this person, another person saying, I went to that person, but I think you should go here. So it just doesn't turn out to be very fruitful for them. They'll also have like coffee chats with various startup lawyers, and these tend to be kind of informal, shorter chats where they get some broad advice, but don't really delve into the very detailed minutia of their problem. And because of this, they're like going for multiple coffee chats and sometimes getting conflicting advice and not sure which way to go. Or they'll kind of opt for some do-it-yourself solution and draft a legal document. But we've heard from some of these companies that when they do that, they're worried that they're not necessarily covering all their bases and they might still be exposing themselves to some liability. So we're still kind of in the research phase of figuring out exactly what this problem is and different possible solutions and maybe how it's been tackled at startup accelerators. So we've been talking to a lot of different teams, gone to presentations by startup lawyers, talked with or emailed with some staff at accelerators, and next week we'll be meeting with the director of a clinic, student clinic that provides startup legal services to kind of see if there might be some way to do something similar on campus here. So if there's any questions or feedback, I'd be happy to hear.
All right, I think so. That's the end of the official presentation. I would love to hear any thoughts, feedback, questions about the many different things I talked about today, or any other thoughts that you have in reaction. John?
Well, this might apply to all the projects. Mm-hmm. The One Justice one brought the question to mind for me. I'm assuming these outside partners come to you with at least some sense for what the challenge is that they're trying to address. So how free are you to reframe that challenge as part of the design thinking process as you do that discovery and really understand at a deeper level what's going on? Yeah. One Justice brought this up for me because I'm thinking about their challenge as it's framed is how do you make sure that more people in court are represented? Maybe the real answer is something about how do you bring more of these family law challenges outside of the court system where representation maybe is not as important. So yeah. How clear you are to reframe that?
So I, as the intermediary, have been trying to get a terrain of a challenge instead of a specific question. I think that's the work I'm doing with the partners is like come with the dynamics, the symptoms, the what's going wrong in many different forms, and then the students have a short 2.5, 3 weeks to figure out what the challenge statement in a quick one-sentence question would look like. But I think that's what we're trying to hold off on is we as the teams are trying to take whatever framings the stakeholders brought to us and then explode them a little bit and then figure out what the right frame is, because that's going to dictate what the solution path is. So we're trying to push back a little bit. Yeah.
I'm actually a student from the National University of Singapore, just bugging around. I have a question. Basically, which area of legal work do you think that design thinking is most sort of best positioned to tackle first as a priorities?
Yeah. Like for me, the Eviction Defense Collaborative is like very ripe. Whenever you can see the relationships right in front of you, where you can see that documents are getting stuck in an hour where it doesn't need to be, where conversations aren't happening very clearly. I think in clinics or any place where there's a lot of visible human touch points, it's very clear where interventions could happen, and we can test very easily to see does it improve. I think when we get to places where a lot of the work is virtual, digital, it's harder to see the effects, but I think there's still a lot of potential there. If we go back to the 4 buckets on the board, I think we can do communication design quite effectively and have tests to see, does this improve comprehension? Does this improve follow-through? Further we get to the buckets over there, like organizational design, it's so much harder to figure out if we do an intervention, does this actually succeed or not? But I think those are some of the most valuable experiments to run, even if the tests, there's no quick and easy way to test. Yeah. Hi, Eddie.
I think that, it's amazing that this class even exists, and it's so great hearing about it. For those of us who aren't, and a number of us aren't actually part of the project do we make sure that we can see the progress or see the results? I don't want to miss out.
Yeah, I don't want to miss out. Well, we're figuring that out, how much of it's public facing and how much of it's not. Because it's the first run of it. We're really happy to have the partners on board, but we don't want to push them to be more public than they're comfortable with. So we're still figuring that out. But I think our commitment is to publish something at the end of it. Because my goal is case studies. My goal is to see what worked, what didn't, be very honest with what succeeded and what didn't. So hopefully we'll be publishing publicly after the class is over.
I don't want to put words in the mouths of my colleagues, but we were watching your slides and just blown away. It's here, so just fantastic.
Well, thanks. Yeah. Any other thoughts? Anyone want to work with us later? Sign up, Kirkland. Great. Well, I really appreciate it. I know probably a lot of you have different interests in the audience. I know some of you are companies, some are law firms. So please feel free to talk to me afterwards. And please talk to the students if you have any brainwaves or thoughts for their projects. They're still at that research phase, so it's really a good time. But thank you for coming out today. I really appreciate your attention.